Hello, and welcome to another edition of Chambers Expert Focus. I'm delighted to be joined today by Travis Mock, a counsel at Rakower Law PLLC. Our conversation is going to focus on commercial arbitration, how to secure it, and how to avoid it in both state and federal court. Arbitration is an essential part of the dispute resolution toolkit for commercial contracts, but using arbitration successfully requires foresight, careful drafting, and sometimes, somewhat ironically, litigation. Travis will be discussing how parties that want arbitration can secure it, how parties that don't want arbitration can avoid it, and how all parties to a contract can improve the arbitration clauses in such contracts to ensure that their expectations for dispute resolution proceedings are met. Welcome, Travis.
Thank you very much, Jonathan. I'm happy to be here.
To get us started, please give us a sense of the role arbitration plays in resolution of commercial disputes.
Sure. So arbitration fills a gap between mediation and litigation, offering some of the advantages of each. Like mediation, arbitration is private. It is significantly customizable to meet the needs and preferences of the parties, and it's relatively more efficient and affordable than litigation, or at least potentially so. We'll get to that at the end. Like litigation, arbitration offers formality. It offers some degree of discovery into facts and documents relevant to the case, although not as much discovery as might be available in litigation. And perhaps most importantly, it offers a final and binding decision that can be enforced through judicial mechanisms. So because of that combination of characteristics, arbitration is an essential part of most commercial contracts today.
And given that it is essential and given that it is so popular, why is arbitration so often the subject of litigation?
Arbitration is a creature of contract. By that, I mean that parties can be compelled to arbitrate only to the extent that they have agreed to do so. That means that they must have agreed not only to arbitrate generally, but to arbitrate the specific dispute or type of dispute that is at issue. A party that agreed to arbitration in a business contract sometimes later develops buyer's remorse. Most often, this buyer's remorse occurs for one of two reasons. First, arbitration is confidential, and a party that comes to want their dispute to be resolved in a public forum will seek to litigate it rather than arbitrate it. Second, arbitration, as I mentioned earlier, offers somewhat less discovery than litigation. So a party seeking expansive discovery will typically need to seek that discovery from a court rather than an arbitrator. Whatever the reason for the buyer's remorse, when a party realizes that the arbitration clause in their contract doesn't suit their needs, litigation over that contract often ensues.
So now we've established some of the reasons why arbitration is so often the subject of litigation. What are the aspects of arbitration clauses that are the most frequent subjects of that litigation?
There are as many variations as you can imagine, but the top three aspects that are most often litigated, I would say, are whether the parties agreed to arbitrate at all, whether they agreed to arbitrate the type of dispute at issue in a particular case, and where the parties agreed to arbitrate. These sorts of threshold questions are referred to as issues of arbitrability. And by default, issues of arbitrability are for a court to decide unless the parties have clearly and unmistakably delegated the authority to decide issues of arbitrability to the arbitrator. Then this is consistent with the idea that I mentioned earlier, that arbitration is a creature of contract and fundamentally based on the parties' agreement.
And if a party wants to compel arbitration, or indeed to compel litigation, what can they do?
With very limited exception, if the dispute at issue affects interstate commerce, then arbitration will be governed by the Federal Arbitration Act. Interestingly, the Federal Arbitration Act expressly does not govern disputes involving interstate transportation workers. But the FAA offers specific procedural mechanisms for compelling arbitration. Where litigation has already been filed, the FAA authorizes a motion to stay that litigation in favor of arbitration. Alternatively, where the counterparty has not filed litigation but simply refuses to arbitrate, the FAA provides for a petition to compel arbitration. The FAA is extremely supportive of arbitration, and the federal courts have interpreted it to be even more favorable to parties seeking to arbitrate than the plain text of the statute might require. And for this reason, parties seeking arbitration will generally try very hard to have their arbitration proceedings governed by the FAA, and ideally to have their petition to compel arbitration heard in a federal court. A recent example of federal court decisions that have expanded rights under the FAA in favor of arbitration is that a recent Supreme Court decision in a case called Coinbase v. Bielski held that where a federal district court, the federal trial court, denies a party's motion or petition to compel arbitration, and that party subsequently appeals that decision, the trial court proceedings are stayed pending resolution of that appeal. That decision effectively protects the party that is seeking to vindicate its right to arbitrate from having to litigate the merits of its dispute in a trial court while it is appealing that trial court's decision to deny the motion to compel arbitration. Similarly, in another recent case, the Supreme Court held that if a party seeking to compel arbitration asks the district court to stay the litigation pending completion of the arbitration, rather than asking that the litigation be dismissed outright, then the court cannot decide on its own to dismiss the litigation rather than stay it. It must stay that litigation. That may seem like a technical distinction, but it has very important consequences that are very favorable to the party seeking to compel arbitration. First, because a court's decision to stay a litigation is not immediately appealable, this decision prevents the party that is seeking to avoid arbitration from obstructing the proceeding by taking an appeal from the trial court's decision to compel arbitration. In addition, because the litigation in the district court remains open for the duration of the arbitration, that district court remains available on very short notice to assist with issues that may arise in the arbitration that require the assistance of a court.
And
If the arbitration is not governed by the FAA, then the arbitration will be governed by state law. And state laws and state courts used to, almost as a rule, be very hostile to arbitration. In most states, that attitude has changed. And most states have adopted at least baseline protections for arbitration, most found in the Uniform Arbitration Act. This includes New York, which has implemented its own version of the Uniform Arbitration Act in CPLR Article 75. Like the FAA, the Uniform Arbitration Act authorizes motions to stay litigation in favor of arbitration, as well as straightforward petitions to compel arbitration. I will give you a hot tip here. If the listener is seeking arbitration in New York, they should be sure to serve the other party with a notice of intention to arbitrate under CPLR Article 75. The reason for this is that sometimes a party will go through an arbitration and obtain an arbitral award, only to find when it attempts to enforce that award that the responding party challenges the arbitrator's jurisdiction or some other threshold issue to the right to arbitrate. But Article 75 provides a remedy for this. If the party seeking arbitration serves a notice of intention to arbitrate that satisfies certain statutory requirements, then the opposing party must promptly move for a stay of arbitration and assert in that motion all threshold defenses to the arbitration that it may have. Any threshold defenses that are not asserted in that motion to stay are waived. A second tip here would be seek expert counsel about the attitudes of the relevant courts toward arbitration. Even though most courts are supportive of arbitration, or certainly more supportive of it than they have been in times past, the courts do vary in their degree of support for arbitration and the procedural protections that they provide. So the court to which a party submits a request for relief can materially impact their chance of success.
Thank you. And what happens if a party seeks to arbitrate, but the opposing party has initiated litigation in a different jurisdiction than the one in which the arbitration is supposed to occur?
So this is an interesting procedural issue on which we could have an entire expert focus. But with very limited exceptions, most courts will not compel arbitration that is to occur outside of that court's own jurisdiction. What this means is that most of the time, the party seeking to compel arbitration must maneuver the pending litigation into a court that has jurisdiction over the place where the arbitration is to occur, and then move in that court to stay the litigation and compel arbitration. If the litigation is filed in federal court to start, it's a fairly simple process to transfer that litigation from the original federal court to another federal district court. If the litigation is filed in state court to start, the process is more complicated. And I will say only that the party seeking to compel arbitration needs to carefully consider and seek expert counsel concerning which options are available to it and which of them would be the most efficient and effective in that particular case.
Clearly quite a few factors there. We'll have to get you back to get into it in more detail. You've already given some handy tips on the use of CPLR Article 75. Do you have any final advice for a person drafting an arbitration clause for a commercial contract?
Absolutely. I'll give you 3 tips. The first is carefully and expressly calibrate the scope of the arbitration agreement. For example, do the parties want to submit any and all disputes arising out of or related to the contract to arbitration? Or would they prefer to take a more targeted approach, submitting certain categories of disputes to arbitration and reserving other categories of dispute for litigation. The second tip is specify the fundamental features of the arbitration. That includes the arbitral forum, for example, JAMS or the AAA or ICC. There are many options. And again, this is an area where expert counsel can help to select the appropriate choice. Specify the rules that will govern the arbitration. Specify the location where the arbitration is to occur. And specify whether questions of arbitrability will be decided by the courts, and if so, by which courts, or whether all disputes concerning arbitrability will be submitted to the arbitrator for decision. The third tip is consider efficiency. I said at the beginning of this conversation that arbitration is, at least in theory, more efficient and cost-effective than litigation. But arbitration is customizable, and parties can easily customize their arbitration in ways that make it far more onerous and expensive than it needs to be. So, for example, don't specify that the arbitration will be heard by a 3-arbitrator panel when a 1-arbitrator panel will do. Unlike in court, parties to an arbitration pay the arbitrator's hourly fees. So having an arbitration with 3 arbitrators rather than 1 becomes much more expensive very quickly. If the dispute is relatively simple, consider opting into the forum's available expedited procedures, which will make your arbitration faster and cheaper. And lastly, don't elect optional appeal procedures if what you or your client really need is simplicity and finality.
Well, thank you so much. This has been a very insightful discussion of commercial arbitration. Thank you for your time, Travis.
Very happy to talk to you. I look forward to the next time.